I do know we're getting some before United Healthcare started to do their authorization requirements. We're starting to get some conflict with them asking for reimbursement for lack of authorization when it was before that period of time that they required authorization.
So they're trying to recoup money that was paid where no authorization was received.
Mm-hmm. Yep.
Yeah. Well, if it was before they changed their policy, I suppose they can do that. I'm not sure there's a good answer to that.
Well, it sounds like it was a timeline that was before they implemented their new authorization policy.
Oh, so they didn't require prior auth at that time?
Yeah, but they're saying that we didn't have authorization at that time, and everything that we see from that period of time, it wasn't required.
Yeah, I think you're going to have everybody educate everybody to appeal those requests. Are they auto recouping, or are they asking therapists to submit that?
I think, yeah, as far as we know, that they haven't said that, but they're and I don't think, not that I've seen, have they asked for a specific amount. They've just announced that some of those visits have been denied because of lack of authorization that, again, wasn't required at that period of time.
That's interesting. So did they get like specific retroactive denial letters that specified which claims they were denying?
Yeah, there were specific patients. That's why we were able to go back and look at their policy in that time and what our contract says at that time. And it was.
Were they Medicare Advantage plan patients or commercial patients, or both?
I'd have to look. I think I can't answer that.
Okay. Yeah, your providers are going to need to send something in writing saying they dispute the claim that they could retroactively deny, or that a authorization was required. They want to dispute that and specifically identify whatever records United Healthcare identified in their letter. Pay attention to whether the letter came directly from United Healthcare or from Optum Health. So you can make sure you know kind of who's pulling the shenanigans. Okay. I think if a specific claim is identified, like a specific data service, they may need to, they're going to need to send a letter disputing. They may need to file it as an appeal. We may need to talk about these cases on a case-by-case basis, because whether an official appeal is required might depend on whether they really have a right to recoup the money at all. So to back up, I have seen Optum Health try to recoup money for overpayments paid to on behalf of United Healthcare in the past, and they've done this a lot, even with out-of-network providers, and where they've had really no right to recoup the money. So you kind of have to analyze the letters and the requests to see if they really have a right to recoup the money, or if they're just trying to get you to voluntarily send money back. There have actually been class action lawsuits on that kind of business practice of making you think you have to send the money back when you really don't have to. And if you send it back without analyzing whether you really have to or not, then that's a voluntary refund. And if you voluntarily refund it, it's going to be hard as heck for you to get it back. So don't refund it if you don't have to.
Yeah.
Make sure you have to first. Their contract should allow them to recoup it electronically if they actually have a right to recoup it, which that is actually another sign that maybe they're not entitled to the refund if they're not automatically recouping it.
Okay.
If they're asking the therapist to just send the money back, then that's a sign they may not really be lawfully entitled to it.
And I've never seen that. Is that they will just deduct it out of the bank account that they deposit into?
Or deduct it from future claims, which is maybe more likely.
Oh, okay.
Yeah, and that's
Geez, how would the EOB even look to the patient then?
Well, and that's another question. If they don't send anything to the patient saying that they're retroactively denying the claim either, then because the patient's going to be entitled to an appeal if there's a retroactive denial. So if they're not sending anything to the patient, that raises the question about whether or not they're even entitled to any money back. So, those are all the things you want to find out, or at least have the PT needs to ask United and call the patient and say, did you get any notice that this claim was being retroactively denied?
Okay.
Is anybody else on the call having issues with United Healthcare trying to get money back from you for claims already paid because they're saying you didn't get authorization when authorization wasn't required? Apparently not. Okay, so we'll open it up for other questions if you guys want to move on to other topics.
So Gwen, we got a little notice here from our spring conference in Chelan is coming up here in March, and we're handling we're doing a Chelan chat, which is, I think you're familiar with it, you've seen it before, but we have a moderator, we have some panelists, and we bring them in and we talk about some hot issues in physical therapy. And there's some topics that we're going to try to tackle here is coming up about high volume. This is kind of, as we all know, it's the response to declining reimbursement is we got to stack the schedule a little bit more, and we're trying to solve the revenue problem with volume, and how the conversation is going to lead into burnout, of course, and then it's also going to talk about how do we keep morale at that level. But do you have any insights on, has there been legally or like contractually with any clinics and their payers, has there been any kind of volume dispute, like volume, number of patients, overlapping Medicare patients, anything like that you've seen be problematic for clinics and clinic owners?
I guess I'm not sure I'm comprehending the way that you're asking the question. I know what you're leaning toward, but are you asking if providers have gotten into disputes with payers because they're having to double up, triple up patients?
Yeah, exactly.
So no, I'm not aware of any. And even if there were, what the payers are going to say, this is the fee schedule, take it or leave it. We aren't involved in telling you how many patients you have to schedule an hour.
Mm-hmm.
So, that's up to you to decide how many patients you have to schedule in an hour. So if you feel like you're being forced to double up, triple up, whatever, more patients than what you're comfortable with, it's because the fee schedule is too low. Maybe you need to go out of network. I mean, that is the simple legal answer to that question. So no, and I'm not aware of any legislation that any state has tried to pass either that has tried to address that problem. You guys had, I think it was Washington that had a bill introduced to require a increase in reimbursement rates for cost of living about a year or so ago. It didn't pass. Do you know about that? Because the chiropractors in the state of Maine are picking up on that bill that somebody introduced in Washington, and have are planning to introduce it here.
No,
You
I don't
should.
know. I don't know if anybody else is on the call who's.
If you don't know about that, you should inquire with your lobbyist whether that's going to be reintroduced. Because the chiropractor I talked to here in Maine, or the association manager, thought that Washington was reintroducing that. It's a COLA bill, COLA, cost of living adjustment. I don't have high hopes for any kind of legislation like that ever passing, because it would require the state to basically take on regulation of fees for healthcare services in order for it to survive anti-competition laws. So, I don't know if it's something that is reasonable to pursue or not, but it's certainly worth having your lobbyist look at it, especially if you're not the one introducing it and someone else is. So you can jump on board if it makes sense.
Lucas, were you going to say something about that?
Oh, just that I do know that I do recall seeing that in the discussions. I think it was through our lobbyist, or just the emails that she sent out, that it didn't pass. So basically what Gwen's saying sounds accurate, but other than that, I don't know anything about it.
Yeah, find out if it's going to be reintroduced. The person I talked to up here in Maine thought that it did actually have a good reception, even though it didn't pass in Washington. So, and I don't know what the details were on why it didn't pass. Let me see.
I wonder if it was a non-specific physical therapy bill. I wonder if that was just a kind of a blanket bill.
I thought it was a bill for all healthcare providers.
Okay.
Yeah.
That's fine.
I'm
Probably
gonna
not on the radar.
see if I know I've got a copy of it in an email somewhere. I'll see if I can pull it up. That would probably be the closest thing you could, or most reasonable thing, I guess, you could attempt to do if it, in terms of legislative efforts to address the issues of low reimbursement, other than going out of network, if you want to address it from a policy and advocacy end of things. What else do you guys have?
I'm wondering, you've been talking about going out of network here for a while now. Are you starting to get some clinics that are giving you positive or negative feedback on how that's going for people who have taken some of your advice?
I haven't heard specifically from anybody in Washington. Just what I'm hearing throughout the country is people are looking at it more closely, going selectively out of network with the lowest payers. And what even a chiropractor friend I have here in Maine recently went out of network with our Blues plan, and she said it was very painful at first because they lost a lot of business. It's they're our biggest commercial payer here, But they're doing okay. They're surviving and they're happy that they did it. Any practice that decides to go out of network has to really analyze what the effect is going to be on their bottom line, because you may have to skinny down your business, but you still may have a better profit margin, even if you do lose business. So if you're prepared to cut expenses, then you may actually do better, just because you're going to make a more profit per visit. So that's hard. It has to be a individual clinical practice decision. Every practice is going to be a little bit different in terms of what your costs are, how many employees you have. It's going to, even your cancellation rate is probably going to impact what decisions you make. So payer mix and all of that taken into consideration. What I always tell everyone to look at, which I think is probably one of the more important things before you go out of network, and you may find out that the information that you're able to get will encourage you to go out of network. You want to analyze who the payers are who have the policies that you want to go out of network with. So if it's United Healthcare, who's the bigger payers in your area who use United Healthcare as if they're third-party administrator, if they're a self-insured company, or get their insurance through United Healthcare. So if it's fully insured or self-insured, if it's a self-insured company, they're highly likely to have out-of-network benefits. So if every large employer in your area that uses United Healthcare does have out-of-network benefits, there's a good chance you're going to be able to maintain a lot of your patients, because they're going to be able to come and see you, and the difference that they're going to pay for their co-insurance or copay is not going to be that significant to deter them from seeking out network benefits. So it's not automatic that you're going to lose all your business just because you go out of network. And that's the biggest thing I think you need to analyze.
Okay. We're getting so much negative feedback from United Healthcare. Is they cover a lot of private insurance around where I live, and they also have Regents drop their Medicare Advantage plan in our area, and so United Healthcare is the other really kind of, when you pull it up, that's the premiums that people want. And so but people didn't know or didn't read or weren't aware that all of their copays essentially doubled. And so
Yeah.
I think if you go out of network and you're already paying your copay, it's not going to make I can't imagine making a huge difference.
That probably one of the bigger concerns patients might have is if they have separate out-of-network versus in-network deductibles, because that could substantially increase their out-of-pocket spending. But that again is going to be dependent on who the employer is and what kind of benefits they choose to offer. By the way, has anybody on this call had any success with taking an appeal to an independent external review and had a denial overturned at that last independent external review level? No one?
No.
Are you talking?
We had a
What was-
denial with, oh, go ahead, sorry.
Lucas.
External review for what were you saying? Sorry.
Either continued visits were denied, or it could have been after services were given, a patient's claims were denied because the payer said they weren't medically necessary. So I'm looking for cases that are compelling patient stories that show a payer using arbitrary procedures that put up a barrier for the patient to receive medically necessary PT services, that eventually, if the therapist takes the appeal all the way to the independent external review, which is usually either the second or sometimes the third level of appeal in a commercial case, then it gets overturned because it was indeed a arbitrary decision on the part of the payer to deny the visits.
We did have, I wouldn't say it's the best case if you're using it as we did have a situation like that where, like for a Med Advantage plan with Regents, we're in the same boat as whoever was just mentioning that Regents dropped Med Advantage in our area. But the last year we had a patient that got denied for a Medicare maintenance situation. And then when we got to the final level of appeal, which was basically a phone hearing in front of a administrative judge of some kind. I'm trying to remember what they called, but I think Regents did a poor job of presenting their case, really. But we got all of our visits covered for what we had asked for that one, and then after that we continued to get denied, and it never seemed like we were able to get back to that point again, to be seen by an external review, which we asked them about, and basically they said that wasn't something we were entitled to, I guess.
Oh, interesting. Yeah, and we're looking for commercial cases more so than Medicare Advantage plan cases. And the reason why I'm asking is because I know somebody who's writing a story on it. And so he's looking for, I'm trying to help him find some good cases of people who are willing to tell their stories. Trina, did you have something to add to that too?
We actually had a physical therapy patient who, when I had called and done many inquiries with their customer service department about visit limits and Evolent over approving, so meaning that she had 25 visits a year, but Evolent allowed us to see her 35 times or whatever. Primera, when I had called into their customer service, stated, yes, that's correct. You can see them over the visit amount as long as it's proven medically necessary. And then Primera ended up denying those extra visits. I took it to the Washington State Insurance Commission, and they ended up submitting it back to Primera and approved those visits after all, and reimbursement on them.
Okay, that might actually be a good case. Can I get your email address so I can communicate with you after we finish this call today?
Yeah, I'll put it, I'll message it out here because it's always very hard to,
Yeah, that'll work. And then I'll email you after.
Yeah, there you go. It's one of those ones that sounds peas, keys, and everything else that mixes in together.
All right, got it. I'll contact you. It might be later this evening, but definitely today.
Okay.
Thank you.
Yeah, of course.
There was someplace else I was going to go with this discussion about fees. I think one of the questions I keep getting asked is, can I add this charge or that charge, a surcharge, a restocking fee? People are kind of making up charges that they want to add to a patient's bill that's not covered, but it's related to the service that was covered. You can't really do that if you're in network. So be really careful about that. In the context of dry needling, though, the most recent person that I talked to, and I can't remember if it was somebody in Washington or not. I don't think it was. Maybe it was. But anyway, they were calling it a restocking fee for the supplies, for the needles and everything. But the real bottom line was that payer didn't pay for dry needling, the procedure anyway. So whether you call it dry needling or you call it restocking fees, I'm not sure that it really matters because neither one of those are covered. But if you're talking about trying to add a fee onto something that you do that is covered, just so you can charge more to make up for the bad fee schedule that you've accepted, that's the wrong approach. I mean, you really need to look at whether you can afford to take the fee schedule or not. If you can't afford to take it, you need to drop it. It's, it's kind of, and it can potentially even get into ethical issues if you're adding on modalities or things that people don't need that really aren't medically necessary and maybe aren't proven to be efficacious types of treatment for whatever that patient's condition is, just so you can add an extra fee for something that's not a covered benefit because you're not getting enough from the fee schedule for what is covered. So do be very careful about that. And especially things like concierge services. People are also wanting to add a concierge fee. If you're offering additional services that are not covered benefits as part of a concierge package, then, and you're making the purchase of that concierge fee optional, not required, then maybe that's okay. But if you're saying to every patient, we charge this concierge fee in order for you to get priority scheduling, or so that we can communicate with you by text and email and phone and all of that, you should be communicating with your patients anyway, when it's necessary. So, charging extra for things like that is probably inappropriate. And having people pay to get an appointment when an appointment is, it should be given, I guess, can also be twisted into probably being a discrimination claim. So you want to be really careful with things like that you're coming up with to try to charge for, that is just an effort to try to make up the bad fee schedule. Any questions or discussion on that?
We did have a question in line with that. We've had some patients that have been late to their, this is massage therapy at our practice appointments. And so we're only contracted with Regents and they will only allow so many units. But if a patient is late and they still would like their massage, we were trying to figure out if there was a way to possibly bill them for the remainder of the units or something of that sort. Do you have any?
Yeah, let me make sure I've got the facts right. So you're contracted with Regents to provide physical therapy and massage therapy services?
Correct.
And they pay for massage therapy separate from PT, or
Correct.
or your massage? So it's not that your massage therapists are doing the manual therapy portion of the physical therapy plan of care.
Correct.
So it's a separate service. Okay, so I don't remember how the massage code is built. Is that a 15-minute unit? Because PTs are using manual therapy versus massage.
Yes, I believe so.
15-minute code.
You can
Yeah, it's the same as PT.
Okay, so the question is, they come in late. You've missed an opportunity to provide massage therapy for, let's say they're 15 minutes late. So you lose that 15-minute code. And then what is the rest of your question? So you want to know if there's a way to charge something, to charge a code that they weren't there to receive?
No, I believe, and Savannah may be able to expand on this a little bit better. Our question was, if they arrive late because Regents requires we bill so many units, if we were able to charge them for the remainder of the lost time. So instead of like a cancellation fee, like a late fee.
Like a late arrival fee?
Mm-hmm.
Okay. All right. So you can't charge it as a massage therapy code because you didn't provide the service.
Mm-hmm.
Regents isn't going to pay for something that you didn't provide. If you're going to have a policy that says if you arrive late, we're going to charge you for that time, That's not covered. You would have to charge the patient for that, not Regents.
That's our intention. So our intention is
Yeah.
to, we were trying to come up with a way where we could see the patient still and still not lose out on that visit. So we were thinking, we would bill Regents for the time that we did see the patient, but
Right.
is there a way we could bill the patient for the remainder of the time that was missed, such as a late fee or something of the sort, without having to cancel the visit?
Well, right. I mean, if they're 15 minutes, 30 minutes late, you can still get in a little bit of treatment, right? I don't know how long your visits are scheduled for, but if
This
you're
would be referring to a 60-minute massage.
yeah, so they can still get 30 minutes and you can still bill for some time, not, lose the whole hour. And then if you have time to continue them into the next hour, if you don't have a patient scheduled, then that's up to you to do that. If you're going to bill for missed time because somebody's late, you're going to need to explain in your payment policies that you're doing that, and make sure your patients understand that you're doing that, and make them sign off something showing that they are in agreement to pay that kind of a fee. It came up in the dry needling discussion last month about what a Washington law that you have that sounded like, and I don't have the language in front of me. Jeremy, do you have that language anywhere? Ben, can't remember Ben's last name, was the one who brought our attention to it, but it basically was a law that it essentially said, as I understood it at the time, in order for you to bill for anything that's not covered, you've got to explain to the patient in advance, and they have to agree to buy the service that's not covered and pay for it out of pocket. I would view something like this, where it's a late fee, as being a similar issue. So I think that there's good possibility that's covered under whatever your state law is that requires you to get the patient's agreement that they're willing to pay for that. So I don't know. That's probably, I've not really heard of other clinics doing that, charging the fee for the missed whatever code you would have billed in that during that 15 minutes or 30 minutes. So it's probably not a good idea. But if you are going to pursue that, I think you want to make sure that that you comply with your Washington law and whatever procedures you set up to do that.
Thank you.
Hope that helps. Yeah. And, anything that you set up like that, even if assuming that it is legal and you can do it, you want to have a statement in your policies that say you can waive that policy at your discretion, because if somebody's in an accident coming to your appointment, you shouldn't bill them for late time for that. If it's unavoidable that they're late, and not their fault, then I think you'd want to forgive that and not charge them.
Oh yeah, absolutely. And we do have a cancellation no-show policy already, but it's one of those things when people show up and they do still want some type of service, but we may not be able to bill for like the minimum amount of units or something of that sort. And so it's just trying to figure out how we could still provide a service, how we could still help people and be a little bit more creative. So
Yeah.
I appreciate that.
Yeah. Next question. Jeremy, I did find the COLA bill that was sent to me. I will email that to you so you can follow up with your lobbyist if it's being reintroduced.
Okay. Yeah. I will take a look at that and forward it off to Melissa. She's our lobbyist. Melissa.
I've got a question if
Yeah.
we're moving to a new one. So I think I know the answer to this, but I wanted to confirm. So talking about the United Healthcare complaints that people have, like I'm assuming it would be considered discrimination to have different scheduling durations or policies for different payers? Like, because they pay flat fees in our area.
Yeah, yeah. That's a good question. I mean, in reality, you can only provide the service that they're paying for.
Mhm.
So if their flat fee is equivalent to 30 minutes, you can't provide an hour, right?
Okay.
Although the language in your contract is probably not going to say that. It's going to say you can't discriminate. You've got to provide whatever services you would provide to any other patient. So there's not a real good official answer to that.
Okay.
I'm sympathetic to your need to really limit what you do with patients like that, because there is an issue with what their cap is at. I mean, again, I guess the bottom line answer is if you can't afford the cap, don't take the contract.
Mhm.
But it's a similar situation to what a lot of PTs in a lot of states have issues with their Medicaid population, because they're really losing money on every Medicaid visit. And I don't know if that's the situation in your state or not, but a lot of providers will have to limit how many visits they make available to people in those programs where they're losing money. And I think you've got a good argument for being able to do that if that's your situation. You can't go out of business because you open your doors to everybody who doesn't pay you, right? So yeah, I don't know. There's not a good answer to that. But I think whatever you do, if you are going to put in place policies where you're going to have to be conservative on the time that you spend with the payers that are not paying for the time that you would ordinarily give, then I think you want to be careful how you articulate what your policy is. Does that make
Okay.
sense?
So
Yeah.
Gwen, in that case, I know there's all kinds of anti-discrimination language in the contract, but wouldn't it have to say specifically, you will not discriminate based on your financial affordability to treat our patients under our particular reimbursement rate? Wouldn't it have to say something specifically about not discriminating against those patients based on what they pay?
Not sure I'm following your line of thought.
Okay. So we're talking about anti-discrimination.
Yeah, I
We're
mean,
talking about changing the schedule, length of the care, um, you know, not using particular CPT codes or doing particular procedures because we know they don't get reimbursed. If we're making a clinic policy that states, okay, all X insurance patients, they have 30 minutes in the clinic and then they're out of here. Is there, and we're getting a flat rate based on how many CPT codes we get, we bill or not? Or does that change? I'm gonna drift. I'm stream of consciousness. I'm gonna drift. If we only bill 2 units because they're only here for 30 minutes, are we only gonna get half of what an hour's flat rate would be?
Oh, I think I see what you're saying. Well, I mean, all of that is going to be based on your contract language. So, if a contract has a fee schedule, I'm trying to think of a good example of this. I think one of the Cigna entities, and I don't remember if it was back in the days when they had OrthoNet or if it was ASH. And again, these are contracts that I've seen up here in Maine. If the contract gives you a fee schedule by the 15-minute code, but caps it at a particular dollar amount, then if you bill 2 units and that's less than what they capped it at, then yeah, they're going to pay you the lesser amount. so you have to look at your specific language and see how it's written. If it is a per visit cap and it's inclusive of everything, whatever you do, then it doesn't matter if it's 2 units or 3 units, right? You're going to get the same amount, or 4 units. So it really just depends on how the contract is written. And you do want to be careful about contracts that that are making it all inclusive, because you really are discriminating if you're not giving that particular patient the same care that you would give anybody else who's got a similar diagnosis. So if your contract says you're going to, whatever care you give, you're going to give all the care that is medically necessary for that condition in every visit, then you're kind of stuck. It's harder to limit what you're providing. On the other hand, if the policy is we're only paying up to 3 units per visit, well, then that extra unit is not covered. You would say that extra unit is not covered. So it all depends on how the payer's policies and contracts are written. Does that help?
Yeah, that helps. Just got to go read those contracts that
Yeah, right.
are hard to even get a hold of.
Just a word of advice on contracts. And if you've got contracts that are really old, try to get a copy of them from the payer. If you don't know where your copy is, you need to keep those on file, and keep files of all the amendments, all the policy changes, because you never know when a legal dispute is going to come up, and you're going to want to have those policies at your fingertips. As an FYI, I don't know if this is on anybody's radar, but there are some new proposed rules to changes to the HIPAA security rule. I just started reading those today. They were published, I think, January 6th. They may come with some additional burdens for both covered entities and business associates. So we may want to be doing a talk on that at some point in the future. At this point, they're just proposed. So I think they are maybe supposed to go into effect within 60 days after the comment period. The end of the comment period is at the end of March. I have not looked to see if APTA has put out any kind of publication about that yet. But it is probably going to affect everybody. So just so you know. What else is on the radar? Question that keeps coming up about whether you have to provide interpreters. That keeps coming up. HHS just sent out a notice to providers about your obligations under the Affordable Care Act for that as well. So if you have had those challenges, then yeah, we may want to talk about that. I don't know. Guys, got anything else? If not, I'll give you back 15 minutes of your day.
I think I'm good.
All right. Thanks, you guys.
All right. Thank you, Gwen.
Thank you.
You're
Thank
welcome.
you.
Bye.
Bye.